haircut. So if there was an agreement among the parties to accept less than par, that obviously wouldn't have violated any of the policy concerns that have been described. And I think very much these negotiations could have been conducted in a different way, a more forceful way. The comparison that you cited to Secretary Geithner earlier, and which is discussed in our testimony, is looking back to the capital purchase program when the 9 banks were summoned to Washington, D.C. And as mentioned in my testimony, that is a pretty good example of what could have been done. Of course, it was the principals that were involved in the negotiations for both sides, whether it was the Secretary, then President Geithner, Secretary Paulson, Chairman Bernanke on behalf of the government, and the chief executive officers of the 9 banks on the other side. That didn't happen with AIG. The forcefulness of those negotiations, being told that this was important for the American people. Now, I'm not suggesting threatening to pull their license or using regulatory authority to punish those that didn't participate, but emphasizing how important it was to the policymakers of the United States government. That didn't happen with respect to AIG. And indeed, again, these were conversations that were done largely over the telephone of mid-level executives. Those 9 executives were summoned to D.C. for the TARP, and they were put around the table. And that communication, that this is really important, and we could, I could continue to speculate and give about 9 or 10 other things that could be said, all I think within the confines of the Fed's policy considerations. Now, we've been somewhat critical of some of those policy considerations, and we disagree with some of them as reflected in the audit. But I think that what's bothersome is that even if you accept all of those concerns, they could have just tried a little harder, and maybe it would have been unsuccessful. We don't know. But as I noted in my testimony, we recently spoke to the French regulator, and they said if the negotiations went something like that, they would at least be willing to engage. And we know that UBS would have been willing to engage. And we don't know what the reaction is of the other potential counterparties, because that telephone conversation from then President Geithner or then Secretary Paulson or Chairman Bernanke saying, hey, this is important, we want you to be involved. We know they were talking to these CEOs on a regular basis, but this wasn't elevated to that level. And we'll never know what the result might have been, but it may have resulted in saving the taxpayers billions, if not tens of billions of dollars, but we just don't know the answer.
Okay, thank you. Mr. Baxter, maybe you've been asked this question before, but in terms of the decision to make the payment at 100 cents on the dollar, were you part of that discussion?
I wasn't in the discussions with the counterparties, Congressman, but I was part of the supervisory team.
How did you arrive at that? Could you tell me?
I can try. First of all, there was a critical deadline, Congressman, of November 10th, and that was the day that AIG was going to announce a $25 billion loss in its 10Q for the third quarter. So we were looking at that, and we were being told by the credit rating agencies that unless something happened with respect to the credit default swaps on or before November 10th, that there was a strong probability of a downgrade. Now, a downgrade would have been catastrophic. It would have brought us back to where we were in September, on the brink of an AIG bankruptcy. So from those of us who were working at the New York Fed, we looked at that as a hard deadline. And the execution risk of failing to get the credit default swaps torn up by that date it would put us back on the brink of bankruptcy. So that was the risk of deal failure. That was the execution risk. So we had to get the deal done. AIG had been unable, as Mr. Habayeb has testified, to get those credit default swaps torn up. On November 6th, Congressman, we got formal authorization from Stacia Kelly, who was then AIG's general counsel, to take over and see whether we could get those credit default swaps terminated by deadline. So we were operating against the clock to do that. Our choices were, should we push for concessions and try to use whatever leverage we had to get those concessions, or should we simply go to par, which would apply to every counterparty? And the way par works is you offset the collateral that these counterparties had been pulling out of AIG against, you offset that collateral against the par price of the bonds. So those were the weighing of the risks as we faced them. And on the one hand, failure to get a deal on or before the 10th would have brought us back to the brink of an AIG bankruptcy. So the risk was in pushing for concession of perhaps 2%, we risked billions of further federal government assistance. Now what happened? We asked 8 counterparties about concessions. 7 said no. 2 of those 7 were French, and they were supported by the French government in their refusal. The one that said perhaps was UBS. It said perhaps up to 2%, but we need to be treated just like everybody else. So had we continued to use whatever leverage we had, and as I said earlier, we didn't have much, we risked losing the deal by November 10th, and that would have brought us right back to September, to the brink of an AIG bankruptcy, and to catastrophic systemic consequences that would have resulted. That balancing led us to see that the solution would be to go with no concessions. We brought that to President Geithner. He agreed, and that's what we did.
Gentleman's
But we
time
brought
is-
it home by deadline. We got it done by the 10th.
Gentleman's time has expired. I now yield 5 minutes to the gentleman from Indiana, Mr. Souder.
Did I hear, Mr. Baxter, did you say that Mr. Geithner signed off on paying at par? He was part of that decision?
He did.
I didn't have that impression earlier, but maybe I misunderstood something. I'm not sure who to ask this particular question to first, but let me ask Mr. Borowski. One of the questions here is, my understanding was to avoid and part of the question for the secrecy was to avoid the risk of the rating agencies downgrading the securities and bonds. Is that true? Is that your impression?
The Federal Reserve has cited as one of the reasons for justifications for paying the counterparties at par was one of the concerns about the effect of the rating agencies and the impact.
Why hadn't they already been downgraded?
Well, they actually had been downgraded up until that point. But
do you believe they were keeping up? In other words, the many hearings that you've been here and so on, it seems to me that to have a private economy work, one thing has to happen is because, you know, CalFed or whatever the big insurance for state employees there is the biggest, I guess, investor, and he said he's only got a couple people to track. If those rating agencies aren't accurate, the whole system collapses, and it seemed to be questionable whether they were moving fast enough in the economy to downgrade it. And in effect here, a partner in the Fed was trying to help disguise it.
I mean, ultimately, one of the observations in our audit is the outsized influence the credit rating agency had throughout this process. As Mr. Baxter just stated, it was basically the rating agencies that were holding the gun to the head of the Federal Reserve, giving them the perception they had to move so quickly. It was the rating agencies that gave the fear to the Federal Reserve, and I'm sorry, I don't mean to, I'm paraphrasing Mr. Baxter, but that fear that AIG would be put into bankruptcy. That was a legitimate fear that the Federal Reserve had because of the result of the rating agencies. And of course, so much of the lead up to AIG's problems were the result of the rating agencies, first overvaluing the CDOs and the bonds that underlie the credit default swaps, and then throughout the process. Indeed, it was the rating agencies who were ultimately looked at the original deal that the Fed brokered with AIG and the high interest rate and determined that too would lead to an eventual downgrade. So yes, they had an outside role in this for sure, for certain.
Mr. Baxter, my question to you would be, how can a free market economy work if the Fed tries to manipulate the rating agencies by pumping money in and trying to conceal that?
We never tried to manipulate the rating agencies, Congressman. We took their observations as they gave them to us, never tried to lever them in terms of what they were going to do with respect to AIG. Instead, what we tried to do was to restructure AIG to avoid a downgrade. Now, in the context of November 10th, and this is an important point with respect to the credit default swaps, had that downgrade occurred, many of the counterparties would have had a right to terminate their credit default swaps, which would have enabled them to keep the cash collateral posted and the bonds. And that is a critical piece here. because the way we restructured these credit default swaps, the Fed took the bonds into our vehicle made in Lane 3. And remember, the bonds had diminished in value from par to approximately half, and the counterparties had gotten collateral for that diminution in value. As those bonds, which we now have in our vehicle, as those bonds come back in value, as our nation emerges from the worst financial crisis in 70 years, we capture that value in a Federal Reserve vehicle. And so it is the offset, if you will, in broad terms, conceptual terms, to the collateral that was posted. And so this is another important feature of the restructuring that the Fed did, which was far, far better than the alternative of allowing there to be a rating agency downgrade
and why
those
did you want
catastrophic
that?
consequences.
Why did you want to conceal that?
But never wanted to conceal that, Congressman. It is, and we tried.
Is it inaccurate to say that you asked for special conditions where where markets wouldn't be able to see for fear they might speculate if they saw that you were taking this position?
Well, first with respect to the Schedule A, to the shortfall agreement, which had the counterparty names, the QSIPs, the tranches, it was never the intention of AIG or the Fed for that schedule to be filed with a shortfall agreement. So there was a misunderstanding in the beginning, I think, as to why that wasn't attached. Now the Commission came back and said, we need that exhibit attached. And then we made an application for confidential treatment because we thought that information would hurt the taxpayer interest in our vehicle. Now the information I'm talking about are the counterparty names, the QSIP numbers identifying the bonds we hold, and the tranches. After the hearing that occurred before this committee in March, we and AIG changed our view on the counterparty names. So the only information today that is confidential with respect to the Schedule A is the QSIP numbers and the tranches, the identifying information for the cards, if you will, that the Fed holds in its hand in this vehicle. That's what we're keeping confidential now, and for the right reasons, because we're worried when we sell out that portfolio that if the street knows what we're holding, it'll hurt the taxpayer interest. That's the only reason. It's not a cover-up.
Well,
Gentleman's time is expired. Now you have 5 minutes to the gentleman from Maryland, Mr. Cummings.
Chairman, Inspector General Bravosky, thank you again for all the work you and your team have done over the last year, and it's been simply invaluable. When I and 26 of my colleagues wrote to request that you conduct an audit of the issues before us today, our main concern was the decision-making process leading to paying AIG's counterparties at 100% par value. However, after Bloomberg and the New York Times published emails surrounding the disclosure, questions began to emerge about how the events surrounding the Maiden Lane 3 transactions were disclosed to the SEC. One of the first things I did was send you a letter asking whether your staff already knew about the emails that were released to the press, and did these emails affect the conclusions that you reached in your audit? I was also interested in whether you plan to open the audit. You responded quickly, as you recall, saying that it was not your policy to comment on open investigations. Is that correct?
Yes.
All right. And I want to clarify, in your office, audit and investigations are different tasks conducted by different personnel in different divisions. Is that right?
That's correct, generally speaking.
Okay. And what are the missions of those divisions?
Sure. Audit, as you know, under ESA, we have the responsibility to both audit and investigate all actions taken under the TARP. The best way to think of audit, it's almost an investigation without the presumption that there was a crime or a violation. It is a review, a historical review of what occurred, and looking to see what went wrong, what went right, and explaining, bringing basic transparency and making recommendations. Our investigations division is a law enforcement agency. We're like the FBI for the TARP. It's populated generally by special agents who have full law enforcement authority, guns, badges, and the authority to make arrests. We also have attorney advisors and support personnel. And when we move something into the investigations division, it's because we're taking a look to see if there was misconduct. If there is some reason or there's an allegation or we suspect in certain cases whether there's a crime or even a civil violation, we do support civil investigations as well, we move it over into that section. So with respect to your letter and the request, we didn't receive many of the documents that this committee received, and including those documents as well as some other documents that pertain very directly to some of the issues directly addressed in the audit. And
does it surprise you that you didn't receive them when you would, I mean, now looking at back?
Some of the documents I'm extremely surprised that we didn't receive. And that's why we're conducting a new investigation to determine what the circumstances were of why some specific documents that we requested were not provided to us.
So an open investigation is not the same as an open audit, is that right?
That's correct, sir.
And I assume you cannot say whether the open investigation is civil or criminal, is that correct?
Well, an investigation at this stage in particular, we're just starting out. We're just taking a look and see where it goes. If it does result in our belief for a referral for civil or criminal prosecution, we would do that. We would then interact with the Department of Justice. We don't have prosecutorial authority. If we determine otherwise, especially with respect to these investigations, we have the option of preparing an investigative report, which will provide to you and this committee reporting on our findings.
Can you tell us what the time frame is for this, or you just have to take your time and face? You can't figure that one out, huh?
We're going. I mean, for us to do this right, 250,000 pages of documents that this committee received, we also received. That's going to take us some time because we really can't determine what we didn't receive until we go through literally every page of those documents. And given the significance and importance of this matter, I usually drive my agents pretty hard and ask them to move very, very quickly. In this instance, I told them, above all, to move quickly, but we need to be very thorough and very accurate. And that will be followed, as all investigations, by a series of interviews once we get our hands around the document. So I hesitate to put a time.
Bloomberg reported this morning that you are, quote, probing whether the New York Fed improperly limited the release of information about payments to AIG's bank counterparties. Is this correct? Or can you comment on that?
Yes. We also have opened a probe into some of the allegations that came here. And again, I really want to stress that when we open an investigation, we're not presuming misconduct or anything like that. It's been suggested that there was misconduct. Again, and so what we're doing, it's our job, our responsibility, our statutory responsibility, when such issues are raised, we have to go look at it. And as I said, if everything was done in a legally correct manner, we'll report that.
I see my time is up. Thank you, Mr. Chairman.
Thank you very much. And now you have 5 minutes to Congressman Backus.
Thank you. Mr. Brobsky, I'm going to ask you this question. You know, Secretary Geithner says that they didn't disclose some things, but now they've fully disclosed everything, and they're trying to inform the American people. However, I think his testimony today appears to mislead the American people. And let me ask you about that. On page 10 of his testimony, he's talking about the AIG bailout. We paid the fair market value at the time for the assets. Essentially what the Federal Reserve did was to purchase these securities from the counterparty with a par value of $62 billion for a purchase price of $27 billion. That's not true, is it?
It is partially true.
Partially true. What they don't say is they got $27 billion of taxpayer funding, and they got to keep $35 billion worth of collateral.
I mean, it is true, in addition to the $27 billion that came from Maiden Lane 3, all that other AIG collateral that they previously been paid, which was made possible largely by the other loan from the Federal Reserve, which was backfilled $40 billion by taxpayer money. And I think in the Secretary's full testimony, he does acknowledge that there is an AIG loss. What we cite in our testimony was a statement that was put out by Treasury, which was completely unbalanced and gave the impression that the taxpayers would be made whole because of that narrow issue of Maiden Lane. And
well,
we think that's
actually what this statement this morning to me says, that they purchased securities with a par value of $62 billion for a purchase price of $27 billion.
It is literally true in the Maiden Lane 3 facility. That is what occurred. It is literally true.
Yeah, he said in the end the prices paid for the securities were their fair market value. That's not true either, is it?
Well, again, with respect to the Maiden Lane 3 part of it, it is literally true, but to look at these transactions as a whole, when you look, the counterparties did receive 100 cents on the dollar for those securities and for tearing up the credit default swap contracts. So the total compensation, when you include the collateral they were able to keep, was effectively par value.
Because the counterparties, they received $62 billion and all, they $27 billion of it paid directly from the special purpose vehicle. Mr. Baxter, Mr. Friedman, you'd agree with that. They received $27 billion from the special purpose vehicle. Is that correct?
I think it's very important, Congressman Baucus, to understand that we paid for multi-sector CDOs with a par value of $62 billion.
Right.
Our vehicle paid $29 billion.
29, all right.
Now 27 went to the counterparties, 2 went to AIG.
Okay.
Another important aspect of this is then we receive those multi-sector CDOs into our vehicle. With respect to the cash collateral that AIG posted,
But what I'm saying...
this is important. This is
But
important.
I'm saying to say that...
We now can recapture that because as those multi-sector CDOs come back in value, as our nation emerges from the worst financial crisis in 70 years...
Well, I understand about the work, but what I'm saying...
Then the value comes back.
But what I'm saying, it was $27 billion, and then it was $35 billion worth of collateral that the counterparties were allowed to keep.
Which they were legally entitled to.
Oh, I understand that, but what I'm saying to say that this, you know, that for $27 billion you got $62 billion worth of assets is certainly not the whole truth, is it?
The whole truth, Congressman, is you have...
No, I'm asking you...
I'm trying to answer your question. You have insurance policies in the form of a CDS. You have assets that are insured. We got the assets. What happened with AIG is they got to tear up the insurance policy that was threatening its survival.
Right. Secretary I understand all that. I mean, I've heard that repeatedly.
That's the whole truth.
But he also says that the fair market value, that you paid the fair market value, but some of these CDOs, some of them were rated CCC or lower, and the market prices at the time, a lot of them were 20 cents and below that. Is that not correct?
Well, Congressman, I'm a lawyer. I won't comment on the value of any particular asset because it's beyond my competence. In our view, in the view of our experts.
Well, BlackRock, who the Fed hired, said that they said there was no doubt that they valued the paper at the average of less than 50 cents on the dollar.
That's in November of 2008.
That would have been somewhat less than $31 billion.
In November of 2008, at one of the worst points in our financial crisis, the loan we made from the Fed to Maiden Lane 3, the vehicle that's holding the assets, is a 6-year loan, and we have a right of renewal. So we can hold these assets.
Well, I understand all that, but I'm saying at the time you paid par for something that was trading. BlackRock says they were trading 50 cents on the dollar.
We paid fair value.
All right.
Gentlemen's time has expired. Yeah, we have to. Now you have 5 minutes to the gentlewoman from New York, Congresswoman Maloney.
Thank you. Thank you very much for yielding, Mr. Chairman and Ranking Member, for holding this hearing. Along with many of my colleagues, we pushed very hard to have full disclosure, and I would like to put in the record letters that I wrote to the Fed requesting full disclosure, along with letters from many of my constituents.
Without objection, so ordered.
Okay. I'd like to get back to Mr. Baucus's questioning, and Mr. Baxter, where you bought the $62 billion for $29 billion. My question is, what's the value now?
The value now, I can't say, Congressman.
Well, did the taxpayers win or lose?
Right as of today, we have a situation where our loan balance is $4 billion less than the amount of the portfolio, which I'll estimate, and I think I need to estimate. Our loan balance is around 17, and the portfolio is around 21, 22.
Well, let's get back to the line of question. I know, and we all know, that we released the names of the counterparties, but I understand that you still want to withhold other information concerning these assets. And what is that information, and why do you want to continue to keep it a secret? We believe in Congress, many of us, that the sunshine is the best disinfectant and anti-corruption and fraud deterrent. So why do you feel this should be kept secret? What is it, and why do you feel we want to keep it secret?
The information that we are still concerned about at the Fed on the Schedule A to the shortfall agreement is information about the CUSIP numbers and tranches of the multi-sector CDOs that the Fed now has in Maiden Lane 3, its vehicle. Our experts, BlackRock, tell us that if we publish that information, when the day comes, and it may be 4 years, it may be 6 years, it may be longer, when the Fed wants to sell those assets, that we will be hurt. We will be hurt because traders in the market will know what we're holding. Like in a card game, if one player shows his hand to everyone else, that one player is prejudiced. So that's the worry. The worry is it will injure the taxpayer interest if we show our hand, if we show our CUSIP numbers and our tranches. So that's the key. And we applied
Mr. Baxter, reclaiming my time, isn't it standard policy for investors to disclose holdings like these in securities filings?
Well, these particular multi-sector CDOs, it is not customary, I am told, for investors to put this information out. And if you do, again, I'm relying on what experts at BlackRock have told us, if you do, you can be gamed by hedge funds and sophisticated players when the time comes when you want to sell.
So you're saying that the public, the taxpayer, would be at greater risk in the ability to reclaim these funds if this information was disclosed. Is that true?
That is true, Congresswoman. I would also wonder why the average American would need to know the precise CUSIP numbers and tranches of the Maiden Lane portfolio. It's the kind of information that, at least in my household, my family wouldn't know how to interpret. But sophisticated players, hedge funds, traders on the street, they could game us if that information was out there.
Going forward, the Financial Services Committee has passed a regulatory reform bill that includes in it a resolution authority, which would be a wind-down authority, so hopefully we would not be in this type of crisis again. And I'd like to ask Mr. Friedman, you say you were privy to this information, but your experience in finance, do you think things would have been different if there was a more formal process for AIG, such as this resolution authority? And could you tell us the difference between government or taxpayers bailing out AIG and Lehman, which is a question many of my constituents are perplexed over? What was the difference between the two in response?
Yes, thank you, Congresswoman. As I mentioned when you and many of your colleagues were voting, the board of the Federal Reserve Bank of New York is ring-fenced away from these supervisory, regulatory, and certainly these extraordinary issues. So I have no direct knowledge from that standpoint of this. As far as, so what I'm giving you is my opinion just as a person who's been around markets for many years. I do believe that for our financial system to work effectively, we have to get away from too big to fail, too intertwined to fail. I think these are dangerous things. And I earnestly hope that as Congress works its way through restructuring our financial regulatory system, they will have some form of resolution authority to give the people who are on the firing line the next time a crunch comes, and one will come at some point in the future, the ability to effect some sort of a conservatorship or resolution to wind down these entities. I think that people who are making money in markets should be at risk of losing money, but if there is not the ability to do this without jeopardizing the entire financial system of the country, and very much including Main Street, I think people get their hands tied behind their back. So I earnestly hope we will have some kind of a resolution authority. As far as the difference between Lehman Brothers and AIG, I have no direct inside knowledge of this. I can say that AIG was to an outside observer, was a much bigger, more complex, and even more dangerous to the economy type of a situation. And there may well have been, and this Mr. Baxter would be much better able to answer than I, there may have been very much a difference in terms of the Fed's ability to enter into it based on the quality of the collateral they could get. But that I can't speak to personally myself.
Gentlewoman's time has expired.
Thank you, Mr. Chairman.
Yield now 5 minutes to the gentleman from Illinois, Congressman Davis.
Thank you very much, Mr. Chairman, and thank each of you for being here. Mr. Friedman, let me ask you, what was the role of the Board of Directors of the Federal Reserve Bank of New York in the decision to compensate AIG counterparties at par?
Yeah, sir, my strong understanding and recollection of our role is that we were, in effect, an advisory board on most issues with administrative responsibilities for things like controls, audit committee, etc. And so we were walled away, ring-fenced away from regulatory issues, supervisory issues, or the extraordinary types of emergency interventions that took place during 2008. If you think of the makeup of the board, during my tenure, something like 6 of the 9 members were either had some affiliation with banks or with financial institutions. So there would have been myriad conflicts if we had been involved. In my experience, the staff of the bank was very meticulous in keeping us involved in these transactions, so I can say that I played no role in any of these decisions or in ratifying them. I've been advised very recently that on the night that the AIG transaction was finalized, I and the chairman of our audit committee received a courtesy summary briefing from Fed officials telling us what had happened and that this would be announced the next morning. So I hope that's responsive.
Well, let me ask, during the time period in October and November of 2008, when the Federal Reserve Board of New York staff were deciding how to address the problems, how to deal with them, did you get any briefings from the staff on the actions that they were taking and the policy options that they were considering?
I have no recollection ever being asked for my views or proffering my views. I have a recollection of after the September intervention with the AIG was carried out, that evening getting a courtesy summary posting from Mr. Geithner telling us what they had done, which would be in the newspapers the next day. And all of this was consistent with the design, as I understand it, of of the statute that a prior Congress passed for how the Federal Reserve banks should operate.
Let me ask, you are on the Goldman Sachs Board of Directors,
Yes, sir.
and you were on the Goldman Sachs Board of Directors in late 2008. Is that?
Yes, sir.
As the chairman of the Federal Reserve Board of New York, Bank Board of New York, Board of Directors, do you think your access to information and the decision-making process at the Fed gave Goldman Sachs an advantage in weathering the storm when there were so many other
Yeah.
firms floundering and
Yeah.
folding?
Sir, absolutely none, because the staff of the Federal Reserve Bank of New York, in my experience, was very careful and meticulous to keep us away from any information that would be of the type of nature you talked about. We had the potential for conflicts was ripe there. You know, the purpose of that board, the primary purpose, as I saw it, was it gave the president of the bank a group of knowledgeable market people that he could get information from as to what was happening in their areas, their business areas, and their communities. And I would speculate that if you had a Federal Reserve Bank in an area in the Southwest, you'd want oil expertise. In an agricultural area, you'd want people with farm expertise. We had a lot of financial market expertise, but the discussions were at the level of what are you seeing in the markets, what are you seeing in the economy. They wouldn't ever tell you what was happening in another bank, which was probably a competitor of one you were affiliated with. And I just think it was handled in a very professional and meticulous fashion.
So the firewalls were
Yep.
there that would prevent any conflict of interest?
In my experience, they were very carefully supervised, sir, and I never had a sense that anyone had any desire to transgress.
Thank you very much.
Gentleman's time has expired. I now yield myself 5 minutes, but I will yield a minute to the gentleman from Massachusetts before I raise my questions.
Thank you, Mr. Chairman. Mr. Friedman, just following up on Mr. Davis's question, I'm concerned about the overall influence of Goldman Sachs in Treasury and at the Fed, and I think your own situation is somewhat instructive. As I understand, you were previously on the Goldman Sachs Board of Directors?
I was, during the period you've been discussing, I was, and I'm still on this.
Right, okay. And then you became a member of the New York Fed Board of Governors?
Yes, sir.
Okay. And while you were there, apparently you owned a significant amount of shares in Goldman Sachs, but that was okay at the time because they were not a bank holding company, right?
Yes, sir.
And then when they became a bank holding company, you had a decision to make, and that was to either divest, right, or get a waiver.
Yeah.
And you applied for the waiver.
Well, the Fed staff applied for the waiver. I did not apply for the waiver.
Okay. And then while the waiver was pending, you bought 37,000 more shares of Goldman Sachs.
Yeah.
What was the thinking behind that?
Let me tell you what the when I went on the Fed board, the Fed Reserve Board, I was a director of Goldman Sachs. I had Goldman Sachs shares, and I would be regularly receiving Goldman Sachs shares as part of your directorship grants.
I get that part, but
Okay.
but if you're not in compliance and you're asking for a waiver, what about the decision to buy 37,000 more shares of Goldman Sachs?
Okay. At the time Goldman Sachs became a bank holding company, I became technically ineligible to be a Class C director. So there were a number of options. I was not going to, at that point, it would not have been feasible for me to resign from the Goldman Sachs board sell all my shares. I had done that several years before when I went to the to take an administrative post in a prior administration. So that left two options. One was for the Fed to basically say, your status has changed, you need to resign, in which case I would have promptly saluted smartly and resigned that afternoon.
Excuse me, sir, I'm sorry, but your answer is, for the last 3 minutes, has been unresponsive. So you knew you were not in compliance, you had to apply for a waiver to stay in that position, yet you bought 37,000 more shares. Can you please, and I don't mean to badger you, but could you answer that part of the question?
I will. My understanding of the practices and precedents of the Federal Reserve was that during the pendency of a waiver, you continued on in your role as a director and the rules were in abeyance. And that was actually the practice of what happened. I continued chairing the board. Ultimately, during this period when Mr. Geithner was tapped to go to Washington.
I still don't understand.
And during this period, I made a decision in December to buy some Goldman Sachs shares. This did not change the eligibility at all because
you just own more gold. Here's the problem: as a member of the Board of Governors, you're making decisions on matters that directly affect Goldman Sachs, and you're former shareholder, current shareholder, and then you buy 37,000 more shares of that company that you're overseeing.
Yeah.
Therein lies the problem. Let me ask you, I notice in dealing with Treasury and the Fed that there are a lot of Goldman Sachs employees all over the place here.
Right.
Is there any type of program where Goldman encourages their employees to sort of salt the regulators' offices that they are regulated by?
Certainly none whatsoever in the sense of, gee, this is some kind of a firm strategy. That I can tell you. What there has been over the years is a certain tradition that you work here, you try to do well for yourself and your family, and then you give back and you do public service. For many years, this was regarded as a very constructive and positive thing.
I can see that.
Recently, it's gone the other way, and people are thinking, is there some ulterior motive?
Well, when push comes to shove,
reclaiming my time. It was, initially it was a minute.
You've been very generous, Mr. Chairman.
I'd ask unanimous consent that the chairman have an additional minute added.
Thank you very much. I appreciate that. Let me just say that we're going to close out. But just before we close, Mr. Friedman, let me just ask you. You still sit on the board of Goldman Sachs, right?
Yes, sir.
And the CEO of Goldman Sachs has said that he didn't need the billions he received in counterparty payment from AIG. He said he didn't really need it. If that's the case, why doesn't Goldman Sachs give back the money? Mr. Friedman, my advice to Goldman Sachs is just come clean and say you need the money and you appreciate the fact that the American taxpayers were so generous. Why not?
You were talking, sir, about a financial transaction where the Goldman Sachs people were in a commercial transaction with AIG.
That's correct.
And they had entered into it at a time when AIG was a AAA company, and they were doing it acting as intermediaries for Goldman Sachs clients. They had worked very carefully in their risk management to protect themselves against a deterioration in the value of these CDOs or in a deterioration of the value of AIG, and they felt that they were fully hedged and had protected their shareholders' interests. I do not think that there is any feeling there that they did anything other than what a market participant would do in the normal course.
You're saying they did not need it. Is that what you're saying?
What I would say was this: Goldman Sachs has consistently said there was something like $20 billion, round numbers for illustrative purposes, of instruments that they sought insurance on, there was a deterioration in the value of that, let's say illustratively roughly half. They felt that AIG, from whom they had purchased this credit insurance, owed them $10 billion. They had $7.5 billion of collateral. That left a shortfall of $2.5. They had purchased insurance on AIG's survival from other major institutions and had collateral and netting arrangements with these other institutions. So what they've consistently said is that their exposure, their direct exposure, and they've used that word direct exposure to AIG, was not material. Now, I am not going to say that, and this may be the point that the SIGTARP made, but I'm not going to say that in the event of a financial Armageddon, all bets weren't off, but they are the stewards for the money of their shareholders.
Right.
And that's the.
Thank you very much.
Mr. Chairman, just a couple of quick UCs. I'd ask unanimous consent that all members have 5 legislative days in which to submit both their opening statements, any follow-up questions on any of our witnesses.
Without objection, so ordered.
I ask unanimous consent that the letters earlier submitted, that if the chair would eliminate his reserve at this time, these are letters that you were copied to a long time ago.
Right.
Hopefully.
Definitely. Still reserving the right to object, but because some of them I'm not sure I've seen, so I want to make certain that we see them. I really don't really see a problem, but just in case there is a problem, I want to reserve the right.
Okay. Well, actually, I'll withdraw my UC on that and simply submit them as new questions for the record. Perhaps
Okay.
that'd be easier.
Without objection.
And then last, the UC on, or second last, the UC on the Schedule A. Are you prepared to withdraw your reservation on that at this time?
I'm prepared to withdraw.
Thank you, Mr. Chairman. And last, earlier you had said that you would compel witnesses to answer. It is a custom of the committee that it be 7 days. Could I have unanimous consent that 7 days after their receipt, they be expected to respond to our questions?
Without objection.
Thank you, Mr. Chairman, and thank you for holding this incredibly successful hearing. I think this is probably our finest bipartisan hour. I think the witnesses, whether they like the questions or not, would certainly agree it was bipartisan. I yield back.
Thank you very much. Let me thank all of our witnesses for being here today, and of course, we really appreciate the fact that you've taken the time to come. And without objections, I enter this binder into the committee record. But before we adjourn, let me state that if the AIG bailout and the government's involvement in it teaches us anything, it shows that deals with the taxpayers' dollars that are made in secret results in distrust and deep, deep, deep disappointment. When taxpayers' dollars are involved, transparency must be first and the last focus of the government. Again, let me thank you very, very much for your testimony.
Mr. Chairman?
Yield to the gentleman from...
Could I, with your leave, just mention one email in particular that I think highlights what you just said?
And let me just say to you, put it in writing.
All right.
He will answer it, and we will move forward. Thank you very much.